Thank you for coming out on this cold, frigid night, and it's greatly appreciated. I'm Lou Schaefer. Some of you might know me because I'm on the foundation board, but this has nothing whatsoever to do with the Jewish Foundation and everything to do with housing. I'm part of the Woodbridge Housing Committee, and part of our goal, part of our duty is to educate, and we're here to have a very interesting conversation. I know I'm looking forward to it on the new Connecticut Act and about affordable housing and what can be done. My duty tonight is I'm supposed to be introducing the introducer. So I will be introducing our chairman, our committee chairman, or chairwoman, Kathy Hunter from the Housing Committee, and she'll be introducing the speakers. Thank you for coming out, and I hope we all, I trust it will be a very informative session for all.
Thanks, Lou. And just a little housekeeping. If you are a member of a town planning, or you're a member of a land use committee, and that's like planning and zoning, ZBA, wetlands, we have a separate sign-in sheet for you, so just make sure that you sign in, and we will make sure that that information gets to the proper authorities. And then you'll get your 1 hour credit for affordable housing training. And so with that, I'd like to introduce our first speaker, Attorney Mark Grants. And he was here a couple years ago, so welcome back. It's great to have you back here. Attorney Grants has over 40 years of experience in municipal land use law, representing agencies, applicants, and neighborhood associations in more than 70 Connecticut towns. Now with Holler and Sage, he continues to guide communities through complex planning and zoning issues. So with that, Mark.
Thank you, Kathy, and thanks you for appearing here. What I'll be reviewing tonight is the affordable and fair housing segment of a course that we do annually through the Connecticut Land Use Education and Research Project at the University of Connecticut. That's CLEAR that you see down in the center. CLEAR holds both basic and advanced training for land use commissioners and staff at their facility in Haddam, Connecticut. If none of you have ever signed up for one of their programs, they have a lot of them. Coastal resilience, and there's a wide range of courses that they offer. And I will tell you that the caterer that they use is extraordinary, and it's worth it just for the breakfast and the lunch, which is just amazing. I always say I work for food when I go there. There are three speakers that day. All of us are from Holler and Sage. We all volunteer to do it. But I'm your speaker for tonight. As Kathy mentioned, Public Act 21-29 now requires a certain amount of training for commission members. It's got to be a total of 4 hours, and one of those hours has to be on affordable and fair housing. And this segment tonight will fulfill your requirement for any of you that are on a commission, so that you're just even 3 hours of other coursework. And I know CLEAR offers it. Connecticut Bar Association also, every 2 years in odd-numbered years, we have an all-day Saturday seminar that also fulfills the requirement. So the next one will be in 2027. We did have it in 2025. We've been doing that virtually, and the last time we had signed up about 650 commission members and staff. When we used to do it in person, we had a cap of 250 and always sold out. And so the virtual format has worked out really well. Everybody gets a front row seat when we do it virtually. Let me get started on this. There's my colleagues who do the other two segments when we do this through CLEAR. As I mentioned, CLEAR has a lot of different programs. They're fascinating. A lot of use of GIS, a lot of coastal resilience, a lot of climate change information. So they have a great selection of courses. And we mentioned again that this is part of their training. Take note, this is not legal advice, unless Holler and Sage is your town attorney. You still need to go to your town attorney. We also, I'm happy to take questions, but at some point I may need to cut that off to make sure I get through my comments before people fall asleep. And there's going to be some polling. We're not really going to be able to do that here. When I do it through Clear, they have a phone app, so you can actually vote on things, but I'll have to skip through those. Let's see, use the chat function. No, you're not going to be able to do that. But if you raise your hand, I'm happy to call on people if you have questions. Just roughly, how many of you are on a planning and zoning commission? Okay, all right. How many on a ZBA? All right, wetlands? So wetlands commissioners also. Other commissions that I haven't mentioned? Which one? EDC, okay, that's good. And
Conservation.
Okay, conservation. Some towns wetlands is kind of conservation of one. Sometimes they're separate. And I'll just mention one other thing. Kathy told you a little bit about me. The only other thing I will add is that I used to be a town planner. I tell my lawyer friends I had an honest job as a town planner, and every time I turned around, there was a legal issue. So I went back to law school and now combine the planning degree and background with the law. I try to be the kind of town attorney I wanted when I was a town planner. And most of my practice today is towns. I do some developer work, but not much anymore. Some of these slides, by the way, are from Growing Together Connecticut and from Open Communities Alliance, and some of them are from Marge Shansky. Some of you may know Marge, she's from New Haven, wonderful land use attorney, a dear friend of mine, and they helped me put together this PowerPoint. So some of why are we worried about affordable housing and housing opportunity? What's the issue there? Well, one of the things is that Connecticut has two different housing crises. One is that we are one of the most segregated states in the country. That map that you see there, the darker color are the most segregated states, and you'll see Connecticut, New York, Massachusetts are highly segregated. And we're going to find out to some extent why that is. We also have some of the highest housing costs in the country, and of course all of you know that. It's the basically on our database now, there are more than 5,000 publicly supported rental houses in Connecticut will have their affordability restrictions expire in the next 5 years. So we're actually losing affordable housing faster than we're gaining it. Housing insecurity is very widespread. In 2025, 25% of renters, 25%, spend over 50% of their income on housing. Now, any of you that have ever applied for a mortgage, you know when you go to the bank does all their calculations, and they won't give you a mortgage unless they see that you can afford that house, mortgage, insurance, taxes, utilities, with no more than 30% of your income. The reason banks do that is because they have found, through hundreds of thousands of experiences, that once you cross 30% of your income for housing, there's a very good chance that you will not be able to pay. That things like housing, transportation, health care will come ahead, and that you will default on that mortgage. So that 30% of income is a really well-tested and well-established standard for what the average person should be paying for housing, and no more than that. In Connecticut, a family earning minimum wage has to work 70 hours a week to afford housing at 30% of their income. And by the way, this slide was just updated. Connecticut increased its minimum wage. This slide used to be 79 hours a week at minimum wage. But we increased the minimum wage, so now it's only 70 hours. So the people that are facing housing challenges aren't people on welfare. They are working people. I will tell you that when I did an affordable housing application some years ago in East Hampton, we pointed out that everyone in the highway department, except the director of public works, all the librarians except the head librarian, all the police except the chief, and all the town employees, including the first selectman, qualified for affordable housing under the 830G program. And this is very typical. In another town, and I won't tell you what town this one was, the zoning enforcement officer there was born and raised in the town where she worked, and was unable to afford an apartment or a home in her hometown. She ultimately got married, and her husband had a house. But she sat through about 10 years worth of hearings on an affordable housing application in this particular town. And she heard the commissioners talking when they didn't think anyone could hear but her about those people who move into affordable housing. And when the case was finally resolved, she quit. And she told them, I am sick of listening to you talk about those people. And it's me. I do your agendas, I assemble your materials, I support you in your work, and you don't pay me enough to live in my hometown. And that, I'm afraid, is what we're talking about. Right now, there are 376,000 families, this is people, that are paying more than 30% of their income for housing, and 135,000 plus that are paying more than 50% of their income for housing. So it is a serious problem. We already talked about it being a highly segregated state. Now, how did we get here? There's a variety of things, and a lot of people don't realize the extent to which different factors created this. Here's a typical deed for a home in Connecticut. You'll see these in land records everywhere. And one of the things it says in small type is that this house cannot be sold to anyone, cannot be sold or occupied by anyone who is not of the white race, except for domestic servants. So you can be black and be a servant, but you can't live in the house as your principal dwelling. These restrictions used to be very widespread, and there's a reason why they were. After World War II, Roosevelt was able to get through two seminal acts to boost the American middle class. One was the VA mortgage, and the other was the FHA mortgage. These were federally subsidized, federally guaranteed, which was in effect a subsidy, so that the veterans returning from World War II or young families could buy a piece of the American dream. They could buy a home. But there was a twist. Roosevelt couldn't get this through Congress. What was then called the Dixiecrats, the Southern Democrats, were opposed to this because they felt, rightly, that black people would be able to buy homes, and they didn't want that. So as a compromise, Roosevelt agreed that the act could say that these mortgages could only be used by white people, and that was in the law. This was not some rogue bureaucrat acting on his own. This was in the statute. So let's imagine two veterans returning from World War II, one white, one black. They wouldn't have been in the same unit because the Army was segregated then. But they could have fought the same battles. They could have suffered the same wounds. They both returned to find the American dream that they fought to protect. They both go down to their VA office. They apply for a VA mortgage, and they're both approved because they're both veterans. They both go to a new subdivision of single-family homes. They both pick out a house. The white veteran buys his house. Black veteran can't, because there's a deed restriction in every VA and FHA approved development that says no blacks or Asians, only whites. So the black veteran can't use the mortgage that he's been approved for because no development that VA or FHA approved will allow him to buy there, or even live there, by the way. Amen. The other thing that happened at around the same time is something called redlining. Banks, in deciding where they would want to extend mortgages, decided that areas that were tending toward black were poor risks. And this was sort of a self-fulfilling prophecy. Because of pure bigotry, if black people moved into a neighborhood, then you had that white flight. And sure enough, the values dropped. And there was another factor there that I'll get to in a minute. So our black veteran says, well, I can't buy in one of these new VA, FHA neighborhoods, but I can go back to my old neighborhood and I can buy a house there. And the answer is no, you can't. You still have your VA mortgage, but you can't because the bank won't loan in those areas. They've decided that those areas are bad risks. One of the things that used to happen at this time, and I remember this from the 50s, yes, I was alive then, was that they had what they called blockbusters, and I don't mean the video store, the long walls video store. What a real estate speculator would do is they would buy a house in a white neighborhood and move a black family in there as tenants. They would then go to the houses around and say, hey, look, a black family moved in next door. This neighborhood's on the way down. I'll take your house off your hands, of course, at a substantial discount, but you better sell to me, because if you don't, this neighborhood's going to hell. Well, people panic, sell, below market, they move a few more black families in, and then they would just keep expanding that, saying, you know, you better move out now. This area is going down the tubes. Banks would see this, they would see this pattern and say, oh, this area is a bad risk. We're not going to issue mortgages there anymore. The speculator doesn't care. They're using commercial loans to buy the houses. They don't need homeowner financing. And so you had that situation where, so now our black veteran can't buy a house in his old neighborhood either. But he still has another option. He can rent an apartment in a suburb, in a white suburb, except there aren't any apartments in the white suburbs. Our white veteran by now has built equity in his house. He sells it. He uses that equity to buy a house in a large, nice, big lot in the suburbs. But there's no rentals there. The houses are expensive in the suburbs. Our black veteran can't follow because he has no equity. And the other thing to remember during this time, and still today, is that if you're a homeowner, you can deduct your mortgage payments and your property taxes from your income taxes. They've limited that, it's called SALT. That's been limited somewhat in the recent tax law, but still is good. And the big, so-called big beautiful bill, they did expand that a little bit. So if you're a homeowner, you get a tax benefit by being a homeowner. Our black veteran, if he rented in his old neighborhood, is still paying his landlord's mortgage interest and still paying the property taxes through his landlord, but he can't deduct it. So he's not building equity, and he's not getting the tax benefits that his colleague, his white colleague from the Army, is getting. So we have this pattern where blacks are basically trapped in urban areas and trapped as tenants. They can't use VA, they can't use FHA, they can't move to an apartment in the suburbs because there aren't any, and they can't buy in their own neighborhoods because of redlining. Zoning was upheld by the U.S. Supreme Court in about 1927. It was called Euclid versus Ambler was the name of the case. Many people think Euclid was referring to the mathematician. It's not. It's Euclid, Ohio, was the city where this arose. And the Supreme Court held that zoning was a health, safety, and welfare matter, and therefore was allowed. But in one of the earliest cases arising out of Euclid versus Ambler, a federal judge said, it was called Euclid 1, one of the lower court decisions. It was in the district court. He said, I'm going to read this out loud. The blighting of property values and the congesting of population, whenever the colored or certain foreign races invade a residential section, are so well known as to be within the judicial cognizance. So a federal judge is saying, everybody knows that when black people move into your neighborhood, it's the end, you know. So a legitimate purpose of zoning is to keep those colored or certain foreign races out of the suburbs. And in fact, that is exactly what they did. Here we are today. The blue line is white wealth, household wealth. The I guess the brown line is black, and the orange is Latino. And you can see that consistently from 1983 until today, that white wealth has been higher. And even with the crash in 2012, whites still remained way higher than their black or Latino counterparts. Today, the percent of whites who are paying more than 10%, more than 30% of their income for housing is 10.19%, compared to black non-Hispanic of almost 27%, and Hispanic of any race more than 30%. So the effects of these policies, 50 years worth, 60 years worth of policies, is being felt in these effects today. Growing Together Connecticut did what they called an opportunity map. They looked at communities across Connecticut and they said, okay, if you wanted your family, your children to get ahead in life, whatever that means, however you define that, what are the towns and cities where the opportunities are the best? And they gave ratings for each city and town. They gave a 1/3, 33%, for the schools and the median income, on the theory that higher income and higher school ratings mean that you're going to have your kids are going to have a better chance, you're going to have better access to education and therefore upward mobility. They gave another 1/3 to the access to employment, where there are jobs, there's hope of prosperity, hope of advancement. They looked at the job growth in that community. They looked at the degree of unemployment. The lower the unemployment, the more employment opportunities there would be for someone moving in. And then they had a factor what they called neighborhood, crime rate, percent of home ownership, percent of poverty. They took all those factors together and they created this map. So the darkest orange are the cities and towns of highest opportunity. The lightest colors are the areas of lowest. And you'll quickly see that the urban areas, Hartford, New Britain, Waterbury, Danbury, New Haven, Bridgeport, Stamford, Norwalk, New London, Norwich, they are the areas of lowest opportunity. Least jobs, worst schools, highest unemployment, worst access to jobs. But then we superimpose over that race. Where are blacks and Hispanics? And the answer is they're concentrated in those same low opportunity areas. So the people who are most in need of opportunity are confined to areas where there is the least opportunity for them. And then we look at how well-intentioned programs have exacerbated this problem. Let me get this first. So we have so non-Hispanic white, only 7% of them live in the very low opportunity areas compared to 47% of the non-Hispanic black and Hispanic 43%. So again, you see this concentration of minorities in the areas where the opportunity is the lowest. We talked about that. And then let's look where public housing is. And these purple dots show where most of the public housing is located. And again, I don't mean to criticize the cities that did this. Cities were trying to provide help to their poorest population. So they built public housing where the need was greatest, which was in the urban areas. But as you can see, the public housing just keeps on concentrating the lowest opportunity people in the lowest opportunity areas. So again, sort of reinforcing that trap. One of the things in Connecticut is that a housing authority cannot build housing outside its own municipality. So the Bridgeport Housing Authority is not allowed to build public housing in Fairfield, and the Hartford Public Housing Authority can't build public housing in West Hartford, East Hartford, or Wethersfield. So they're forced, if they want to address the needs of their community, and it's good that they are, they have to keep reinforcing those same patterns that we've been seeing all these decades. So what are the laws about zoning? First of all, we have the fair housing laws. The federal fair housing law prohibits policies that have what's called a disparate negative impact on minorities. Disparate impact means that although the words in the zoning regulation don't say no blacks, that becomes the effect of it. That's what happens. If you have no rental, if you have no high density housing, based on the factors that we've just seen, you are effectively saying that minorities can't live in your community. The Connecticut Public Acts have for at least 50 years, both in 823 and 82, which we'll get to in a minute. The law in this state has always said, if you want to have the planning power to adopt plans of development, the power to regulate subdivisions, those are both planning powers. If you want them, you must plan for affordable housing to meet the regional need, right? And you must plan for housing choice and economic diversity. Public Act 21-29 boosted this. It reinforced this, and one of the things that Public Act 21-29 did was it took out of the statutes, one of the things that used to be in 8-2, it used to say that in applying or adopting regulations and implementing them, you can consider the character of the neighborhood. That phrase was used over and over again to defeat higher density housing. So it was deleted. It now is the physical characteristics, and that is only where those physical characteristics are articulated in the zoning regulation. You have to say exactly what you mean by physical characteristics of the neighborhood. So they made it a lot harder to do that. But even before 2021, the law required towns to plan for higher density housing opportunity. I'm going to skip that one. 8-2, which is the zoning, same deal. No town, by the way, is required to have a planning commission. No town is required to have a zoning commission. A couple of towns don't have zoning, as a matter of fact. I know Eastford doesn't. They may be the only ones left. So you don't have to have zoning. But state law says if you're going to have planning, you have to plan for housing opportunity. And if you're going to have zoning, you have to encourage the development of housing opportunities, including opportunities for multifamily dwellings and so on. So the law has always required towns to zone for multifamily. One of the things that 21-29 did was it boosted that requirement. It made it more emphatic that you had to designate certain areas for multifamily housing, even though most towns have not done it. Part of the response to this imbalance, to this problem, was the adoption of Connecticut Section 8-30G, the Affordable Housing Act. It was modeled on a program from Massachusetts that, with some differences, and what it does is it creates two different kinds of affordable housing. One is assisted housing. That's housing that has government money in it. It might be your housing authority, it could be Section 8 vouchers, it could be CHFA mortgages, it could be something, many cities and towns, growing number, are adopting ordinances that give tax abatements to affordable housing or other forms of benefit. And although it hasn't been tested yet, I think those kinds of incentives, those kinds of subsidies would allow it to be considered as assisted housing. And then there's the set-aside development. That's the one you've heard the most about. That's the one you read about in the papers. That's the one everybody turns out with the torches and everything. That's where 70% of the units are market rate. Developer can rent or sell them for whatever the market will be. But 30% of them have to be deed restricted for 40 years to persons who qualify for affordable housing. Of that 30%, half, so 15%, have to be for families earning no more than 60% of the median income of the area, the county, or the state, whichever is lowest. The other half, that is 15%, for persons earning less than 80% of median income. And as I said, the rest otherwise. The deed restriction is for 40 years. And again, some of the early 830G has been around for about 30 years. So some of those restrictions are expiring in the fairly near future. The things that a developer has to do when they submit an affordable housing application is include what's called an affordable housing plan. The first thing it has to do is designate an administrator for the plan. The person who will qualify the buyers or renters as being at 60% or less of median or 80% or less of median. I will tell you, I have to be careful, I know this is being recorded. It is my opinion that except for a developer with a proven track record as an administrator, and there are many of them out there, by the way, the developer should not be the administrator. They were nearly always proposed that they will be the administrator. So ask yourself this: if you were the owner of an 830G apartment building, and it was your job to rent 30% of the units at below market rate, at less than you could get on the market, how conscientious would you be about that? Especially if nobody's watching you, right? That's why I don't think it's a good idea. The ideal solution is for your local housing authority to be the administrator, because that's an agency whose job it is to provide housing opportunity for people in your city or town. If you don't have a housing authority, you should create one. It is one good way for you to meet some of your obligations under the Affordable Housing Act and also under both A2 and A23 for planning and zoning. I'll mention you something that last year I did a number of years ago. You know how every now and then we have these boom and busts in real estate, and you'll have a real estate bust and there's lots of foreclosures and so on. One of the things that the Housing Authority in Glastonbury did a number of years ago was there are a lot of condominiums being foreclosed. The Housing Authority went to the foreclosure auction and bid on the condominiums and bought them. This had several good benefits. First of all, they were nice units, scattered site. You weren't concentrating lower income people in one area. Second of all, the Housing Authority didn't have to worry about mowing and all those things all over town. They were condos. So the mowing and the plowing and all this stuff was done by the association. And then the third thing was that they were able to provide nice housing at a bargain price. These units weren't built using Davis-Bacon. They didn't have to be union labor. They were built privately. So they were in foreclosure. So they got really good buys on some of these units. That's something that a housing authority can do. They can buy units anywhere that are affordable and then rent them out to people who are in need. But as I said, the other reason to have a housing authority is just if you get an 830G, you can say we require that the administrator will be our housing authority. The other benefit to this is having your housing authority as the administrator is if you're you're not allowed in an affordable housing application to say that first dibs go to local residents. You can't do that. But if the office where people apply for these units is in your town, you're making it easier for your own residents to access those units. As opposed, there's an agency in Hartford that does a lot of A30G administering, and they're very good at it. But if you're down here and you pick a Hartford administrator, you're making it a lot harder for your own local people to get online and get that housing. So I would suggest that. They also have to have an affirmative marketing plan, that is that they market these units to minority communities. They have to have a calculation that shows how they're determining the 60% of median, the 80% of median, and what the costs are in the case of rental or purchase. How they've calculated that rental or purchase price. They have to include all housing costs, taxes, insurance, utilities, everything. Okay? So you want to make sure that if you get one of these, that you're checking that. They have to describe where the affordable housing units will be located, and they're not allowed to concentrate them. They have to scatter them throughout the development. We had an application some years, I won't tell you what town it was, in one of my client towns, where about 2/3 of the units had this beautiful view of the river, and the others were up against Interstate 95. And the developer said, well, I'm going to make all the ones up by I-95 with no view of the river. I'm going to make them the affordable. And the town said, no, you can't do that. You have to distribute them throughout. You can't create another ghetto. We already have enough of those. They can have draft rules and regulations. One of the questions, I guess, it used to be that developers would bring in a set of regulate their own zoning regs. You see that less now. And then they have to bring in a plan of what they propose to do, and all 830G developers do that. Now, how is the 830G different from the things that you as zoning commissioners typically see? With a typical development, the project has to comply with your zoning regs. In a set-aside development, an affordable set-aside development, you can take your zoning regs and your subdivision regs and just chuck them out the window because they don't apply at all. Nothing to do with it. In the typical application, the burden is on the applicant to show that they comply with those regulations. They have the burden of proof. In an affordable housing application, it is the commission that has the burden of proof. And they have to prove that this development will have substantial, that's the word from the statute, substantial adverse impacts on health, safety, and other matters the commission may legitimately consider. That other matters category has been very narrowly construed by the courts. Environmental counted once, and the Coastal Area Management Act counted once, yes? Wetlands is not subject to the 830G burden shifting. So the wetlands agencies continue to apply their regulations. The only thing I will say to you on that is, for the first 20 years of the Wetlands Act, the Connecticut Supreme and Appellate Courts almost uniformly upheld anything that the Wetlands Commissions required. They considered it a vital, correctly considered it a vital environmental protection law that protected groundwater and drinking water and a whole series of other things. And the courts just uniformly upheld wetlands, almost immediately did. That began to turn with a case called Avalon Bay, where what began to happen is people began to see the Wetlands Commission as their first and last bastion against affordable housing. And so wetlands commissioners were pressured to push, I'll be kind and say to push their authority to block affordable housing. And so what began to happen is that in affordable housing cases, the Supreme and Appellate Courts began to rule against wetlands agencies. And the problem with the way our judicial system works is, if a court makes a ruling in one case, it's deemed to apply in all comparable cases. So for example, in the Avalon Bay case, the court ruled that that wildlife is not a valid consideration for wetlands. Now, that's really odd, because if you look at the preamble to the Wetlands Act, one of the things that's right in the Act, it says that we protect wetlands because of their habitat value. So it was an interesting case that the Supreme Court said you can't consider wildlife, but here's why. It was Weston. Avalon Bay was, I think it was Wilton Weston. Anyway, what had happened was a developer had gotten a luxury condominium development approved many years ago. But economic turned down and never got built. The luxury housing, the luxury condo, was in a certain envelope of development. And not too far away was a vernal pool. Vernal pools are very important environmental habitats for invertebrates, frogs, salamanders, and so on. When the luxury condominiums were approved by the Wetlands Commission, the frogs and salamanders did not object. They were fine with it. They were okay with the luxury condo. But then 20 years later, the developer came in with an affordable development within the same development envelope. No greater area of disturbance. Suddenly, the frogs and salamanders were outraged. Neighbors hired a scientist who said that he had found 3 frogs. The developers, or I think 5, the developers experts said he'd found 3. They turned it down, wildlife. And so what happened, I mean, interestingly in that case, the developer's position was the commission abused their discretion, which is kind of your normal argument. But what's called an amicus, friend of the court. An amicus brief filed by the Connecticut Home Builders took a much broader approach. They said wetlands agencies can't regulate wildlife at all. Now, when that argument was made, most people thought that's pretty extreme. But the court adopted that. They adopted the amicus position. They said you have no authority over wildlife, period. That was fixed by legislation to some extent, not totally. But I guess the takeaway here is that the wetlands agencies are not subject to 830G, but if you let yourselves get pushed into abusing your power to block affordable housing, you're going to hurt every wetlands agency in the state, and it has happened. It has happened. In every case that I know of where wetlands agencies' decisions overturned by the courts has been an affordable housing application. Because the courts have had it. They've simply had it with the fact that salamanders and such are okay with luxury condos and not with affordable. They're not buying that anymore. Okay, so it's the commission's burden to prove that it will have a substantial adverse effect on health, safety, and the very narrow other matters. In a normal application, normal zoning application, if you see a defect or a problem with an application, you can approve it. You can approve it with a condition or a modification to fix that problem, but you don't have to. In an affordable housing application, if you can fix the problem with a condition or modification, you must do so. The idea here is not a denial based on some technical or trivial thing that's readily fixable. In a standard development, the law says that you're supposed to state your reasons for denial, but if you don't, the court will search the record. So it's not a big deal. In a affordable housing, the commission must state their reasons, and those reasons must be specific and they must be supported by what's called substantial evidence. Substantial evidence is generally expert testimony that something is reasonably likely to occur. Right? One of the things you often hear, I've heard this myself, people come in, if you put a road there, and if an oil truck turns over on the ice and then it's struck by lightning, and then there's, oh please, you get this kind of stuff, okay? That's not, the fact that something might happen is not substantial evidence. And this has come into play largely with expert testimony, where experts, due to their training, they often will say something like, I am concerned that, or I feel there's a risk of that, or I think there's a possibility that. None of that is substantial evidence. So people saying, I'm worried about the traffic, or I'm worried about the environment, none of that is evidence. In the case of a standard application, the court reviews only the evidence that supports the commission's decision. But in an affordable housing application, the court is supposed to do what's called a plenary review, which means they review all the evidence. And there was just a case by Judge O'Hanlon, just like last month, where Judge O'Hanlon just ripped the town's engineers into little tiny pieces because he felt that he had expressed opinions that were not supported by substantial evidence. In your typical development, the court can sustain the appeal, that is say, yes, you win, dismiss it, you lose, or send it back to the commission. But in the Affordable Housing Act case, the court can modify, can not only do that, they can also say, okay, we're going to change that, and they can remand it for very narrow purposes. There was a case out of Fairfield where there were 3 very technical issues that came up on appeal, and this trial judge said, okay, developer wins, but I'm sending it back to this commission to address these 3 very specific things. And when the developer went back to the commission treated it as a whole new proceeding, all new experts, all new evidence, all new issues, and denied it again on all whole new grounds. When it came back to that same judge, the judge said, I told you to focus on these 3 very technical things. Instead, you went off the reservation, going wild on it. You lose. This is it, you're done. That went to the appellate court, and the appellate court agreed that the commission had far exceeded their remand. But the other thing that happened on that one was the developer sued the town for $3.4 million for lost income. He's saying, you violated a court order, and by doing that, you cost me money, and I want it back. They did settle that case. The developer did get a substantial benefit, I'll say. All right, in the case of a typical development, if there's a denial or conditions that are unacceptable to the developer, they go straight to Superior Court. That's their only option. In an 830G application, on the other hand, they have that same 15-day appeal period to come back to the commission with a modified proposal to respond to whatever were the claimed grounds for denial. So you notice the pairing here. The commission has to state specifically why they denied it, and then developer gets the second bite of the apple to come back and at least try to address those very specific things. If they're denied again, or in their opinion unreasonably conditioned again, then they can still go to court. The hope of this provision is that maybe they'll actually work things out locally and save the court some time and effort. And then lastly, we just talked about this, 50 days to appeal, or instead they can go back on the new thing. So, some other things about 830G applications, about set-aside developments. The fact that the project is modified during the review process is not a ground for denial. This has been tried sometimes. The commission finds flaws in the application. The developer does what they're supposed to do. They fix it. And this happened to me in one town, by the way. 24 hours before the hearing closed, the commission sprung a whole new issue on the developer, who was my client in that case. And 24 hours. Within that 24 hours, we redesigned our plan so that the final night of the hearing, we said, okay, you made a fair point, commission. We're fixing it. And the commission said, oh, it's too late. We don't have time to review that now. You're denied, right? The court did not buy that, as you can imagine. We talked about the 15-day appeal period. Or if they come back for that second bite of the apple, they have 65 days to make a decision. If there was a public hearing on the original application, they have to have a public hearing on the resubmission. A failure to rule is not automatic approval, but it is rejection. All right. 830G does not apply to towns where 10% of the dwellings in the town are already considered affordable. And the ones that are affordable are that they're assisted. Again, your housing authority or a program of that kind. CHFA mortgages, again, that's a form of government assistance. Existing set-asides that are already in your town. Mobile home parks, if they have the deed restriction for 30% of the units for at least 10 years. Some mobile home park owners, by the way, will agree to a deed restriction because they're really renting them. They're renting the pads for affordable prices anyway. Always worth trying. And also counted are mobile homes in resident-owned parks. I know right now the town of Colchester is drafting, or may have already drafted, a zoning regulation that allows resident-owned mobile home parks because they recognize that those are 100% affordable and count toward their 10% requirement. And I believe their regulation requires what are called double wides, the ones that look like a ranch house. Once they're in play, by the way, the word mobile home is so misleading. They're factory built. These days, they don't move anymore. Once they're put down, they never go anywhere. If 10% of your housing doesn't meet that, then you're subject to the set-aside applications. Towns that had 30 years to comply, of course. Let's see. Moratoriums. Let's take a minute about moratoriums. One of the things that happened in the early years of 830G was a town was at 2% affordable housing. They said, we'll never reach 10%. What's the point? Why even try? You may just give up right now. And so the General Assembly thought that was a legitimate problem. And so they inserted that if you make 2% progress over any time period, by the way, since the adoption of 830G, if you gain 2% of your housing as affordable housing, you will get a 4-year moratorium during which no 830G applications need to be approved by you. The burden shifting does apply. If during that 4 years you get 2% more, then you get another 4 years, and so on. So some towns have taken advantage of that. I think Westport just got a moratorium. I'm not sure what other towns. And that's, by the way, that's where having a housing authority comes in. Glastonbury has just gotten approval, zoning approval, and other approval for, I think, about a 65-unit housing authority development. And 100% of that will count, because it's assisted, it's government money. 100% of those units will count toward the town's 10%. I'm not sure if that will get us to our 2%, but we have right now about 165 unit 830G set aside. So 30% of those units will count. And we have another one under construction, it's like 30 units. So it could be that Glastonbury will get its 2%, you know, in the foreseeable future. We'll see. But that's a way to give towns an incentive to say, look, get 2% progress. You have 4 years to catch your breath and plan for the next 2%. We're not going to do that one. There are alternatives to 830G. One of them was what's called 8-12M incentive housing. A planner friend of mine calls this the kinder, gentler 830G. This is a voluntary program. You don't have to do this. But if you zone an area for what are really fairly high densities, 6 units per acre for single family, 10 for duplex or townhouse, 20 per acre for multifamily. If you create such a zone, and you can, if you're a town of under 5,000, you can request slightly lower densities. Those units count toward your 10% or your 2%. And it's a way that towns can be proactive. One of the things about 830G is, as a former town planner, 830G is really the antithesis of good planning. Good planning should be where you designate where in your town is most appropriate for higher density multifamily housing. With 830G, a developer just finds a piece of property that works for them, and you get this high density housing plunked down. Maybe it's nowhere near major highways, maybe it's nowhere near your employment centers, maybe it doesn't have public transit. There are all kinds of reasons why maybe it's really not the right place, but you didn't put it anywhere else, so you end up, reacting to what the developer does. 812M was intended to give you an incentive to be proactive. And the state provided planning grants to cities and towns that were willing to plan for where the high density was most appropriate. One of the drawbacks to this program was those densities. Interestingly, the Connecticut Home Builders Association said these densities are too high. When you hear the Connecticut Home Builders say that something is too much, you know you've really gone too much. And they said our members just don't build at these densities. We're just not used to doing this. And I represent the town of Haddam, and Haddam really does want some affordable housing. They hired a consultant. Haddam is 55 square miles, but no sewer and water. They could not find a single spot in the whole town of Haddam where they could develop at these densities. And they were sincerely looking. So this thing has not been used very much, unfortunately. There were other problems in the program too that arose from the Department of Housing that we won't get into. Other things you can do, accessory dwellings. Even under Public Act 8002, the brand new one, an accessory unit does count as an affordable housing unit if it's deed restricted. It has to be deed restricted. But the irony here is most accessory apartments will rent out at affordable levels anyway. They're usually small, right? So they're going to rent at that level anyway. And it doesn't change the character of the neighborhood. Most of these accessory apartments, just a tack on or conversion or whatever. The Public Act 8002 restricts things. You can no longer require that they be physically connected by a breezeway. There's a number of things they no longer allow you to do, but they still do let you count them. Tiny houses, allowing higher density, smaller units. Public Act 8002 really exempts what are called cottage clusters, which are clusters of smaller homes on smaller lots around a central green. Manufactured housing, I mentioned Colchester, that they're pursuing a regulation to allow mobile manufactured housing. 8-2I is called inclusionary zoning. It's been in the books for years, but a lot of people don't know about it. It allows you to adopt a zoning regulation that mandates the inclusion of affordable housing in new residential developments. So, for example, if a developer brings in an apartment building, and of course they want the highest rate they can get, that's America, it's the free market economy. You could say we require that 10 or 15 or 20% of those units must be deed restricted at 80% of median or 60% of median or half, and however you want to do it, right? But 8.2I authorizes your zoning commission to adopt a regulation that mandates a certain minimum percentage of affordable housing in new developments. Could be a subdivision, could be multifamily. The only problem with subdivisions is, obviously, let's say you're going to use 10%, right? It has to be at least a 10-lot subdivision because you can't do a fraction of a house. But you can do that kind of thing, and many towns are pursuing that now. Glastonbury, where I live, just did. I think they first did 10% mandatory, then they realized that they weren't making any progress toward the goal. They were just standing still, so they changed it to 15%. So they get a little bit of gain on their 10% goal. But that's something that you can do, and you can create overlay zones with density bonuses. So you can say we'll allow you to build at a higher density in this location if you include a certain percentage of affordable housing. So a lot of options that are there for you. And of course, having a housing authority, as I mentioned before. We talked about 8.2I already. I think that's sufficient. Now 830J, which just disappeared last month, 830J rather, required towns to adopt affordable housing plans. As you can see, by spring of 2022, a lot of towns didn't do it. The ones that did do it, unfortunately, those plans were eyewash. They were frequently just just very generic, very broad, nothing specific. And in frustration, this new public act, they got the one that was signed, 2 weeks ago or something, that one does away with that and comes in with a different system where now towns and or regional planning commissions can adopt affordable housing plans. They will be reviewed by the Department of Housing. That's where we are for affordable housing. Maybe we can pause there for questions on affordable housing, on inclusionary zoning, 830G, set-asides, anything like that. We'll have time for questions afterward too, because now I'm going to a different topic. This is fair housing. This is not affordable housing. Connecticut has a Fair Housing Act, and so does the federal government. They are intended to reduce racial segregation and other forms of discrimination, ethnicity, whatever. One of the things that happened, though, and this is why I wanted to do this, is because a lot of people didn't figure this out. Prior to 1996, we had the Fair Housing Act. The Fair Housing Act basically prohibited discrimination in housing. No surprise there. It also had a provision that almost nobody knows about because it's so silly. It actually says in the Fair Housing Act that zoning cannot discriminate on the basis of race or ethnicity or so on. So, for example, a town can't have a zone for black people and a zone for white people. It can't have a zone for Italian Americans and a zone for Polish American. And the reason nobody thinks about this is who would do it? It's so silly, okay? But it is in there. It's in there, right? That you can't have zoning that discriminates based on these factors. The Americans with Disabilities Act said that government and public conveniences must make a reasonable modification or reasonable accommodation of disabled persons. And disabled persons is defined more broadly than you probably think it is. Sure, the person in the wheelchair is a disabled person, but disabled includes both mental and physical disabilities. So mental disability, we'll get to this, but so the ADA always said that you can't discriminate, always said you can't discriminate based on disability. What happened in 1996 was that these two existing federal laws got married. They added to the list of things that zoning can't discriminate against, they added disabled persons. So now in addition to zoning not being able to discriminate against blacks or whites or Italians or whatever, they also cannot discriminate against disabled persons, and they must make a reasonable accommodation for the needs of disabled persons. So what does that mean? Okay. Who are disabled people? With a physical or mental impairment that substantially limits one or more of life's major activities. They have to have a record of such impairment. So for example, the guy who breaks his leg skiing and is in a wheelchair is not a disabled person, all right? He'll get better. And they have to be people who are regarded as having such an impairment. Now, you're gonna ask me what that means, and my answer is I have no idea, all right? But that's what's in the law, people who are regarded as having an impairment. So, people who aren't covered by FHA, people who currently use controlled substances, drugs, whatever. People who are substance abusers currently are not disabled, even though that may have disabled them. People who sell or manufacture drugs, obviously. People who are a threat to public safety, naturally. Largely for transient, so a Marriott courtyard, all right, it's not a residential development, even though people may stay there for a long time. So they can't be denied the benefits of public services or programs because of their disability. So major life activities, eating, sleeping, thinking, communicating, operation of a bodily function, those are disabled people. The fact that someone successfully manages their disability does not mean they're not disabled. All right, they're still disabled and they are still entitled to protection under this ADA, FHA marriage. People who are recovering from the effects of substance abuse are disabled. People don't have to be in a recovery program, and you can't set a minimum time that they were sober or clean, and you can't say that they're only families with children. Right? So where you get into this in the zone, where one of you, if you haven't already, or you'll get in this, are the so-called halfway houses, the group homes for people with various disabilities. It could be drugs, it could be mental disability, it could be any number of things. The FHA ADA now says that you have to make a reasonable, you'll always hear reasonable accommodation, but frankly the right term for our purposes is reasonable modification. That you need to modify your zoning if it has the effect of prohibiting disabled persons from occupying residential areas in your community. There are different ways that this failure to modify can occur. One is where your regulations just, I won't tell you what, again, I can't tell you what city this was, but one of the city that I represent wanted me to draft a temporary moratorium to prohibit housing for disabled persons in their city. And I just said, you absolutely cannot do that. I mean, you're painting a target on your forehead if you do that. There are still today towns that have in their, I've seen it have in their zoning regulations, that mental hospitals are prohibited in our town. You categorically cannot do that, right? So you're asking the Justice Department to show up at your door if you have a zoning regulation like that. The more common one is what's called disparate treatment. A law that looks neutral on its face has the effect of disadvantaging disabled persons. And then disparate impact, where again it's facially neutral, but it tends to affect disabled persons. So, and that's where that's what you're going to see in your towns. The theories under which a town can be prosecuted are intentional discrimination. I was mentioning to Kathy before this started. I served a 7-year sentence on my own planning and zoning commission in my own town, and the most controversial application we ever had was a home for people for Alzheimer's patients, which you would think would not be controversial, but we were walked to our cars by police officers because the neighbors were waiting for us in the parking lot, and they were waiting without welcoming arms, I assure you. Right? So, to intentionally say we're not going to allow disabled people in our town, that's obviously that there's disparate impact, which I mentioned, that it's facially neutral, but it has the effect of being disadvantaging disabled people, and then a refusal to make a reasonable modification of your rules. This often ends up at zoning boards of appeals, which, by the way, it shouldn't. It often does, where someone's looking for a handicapped ramp in a setback. Right? All of you ZBA folks have been told, have beaten into you that hardship is not personal. It must be hardship to the property. You've all been told that. But federal law says that a reasonable modification under ADA you have to make that modification in some way, right? And it will often end up before ZBA. And yes, it's a personal hardship, but you can consider it. You can issue the variance. And in fact, in many cases, you have to issue the variance. The only thing I'm going to tell you about that is ADA does not totally preempt local zoning. Reasonable accommodation. What's a reasonable accommodation? There was a case that came out in New Britain a number of years ago. Typical subdivision, all the houses in a row. And someone came in for a variance for a handicap ramp in the front yard because his wife was confined to a wheelchair. The neighbors showed up at the hearing and said, look, we know they needed ramp. We know Mrs. So-and-so is in a wheelchair. But could you put the ramp in the back so it doesn't ruin the streetscape? And Mr. Whoever said, no, my garden is in the back. I don't want to put that ramp, I'm going to lose my garden. I want it in the front. The ZBA said, well, you're getting it in the back. We're going to give you a variance, we're going to put it in the back, right? He appeals, failed to make a reasonable accommodation. The court says, no, they let you have the ramp. It doesn't say that it has to be in the front yard. You admitted you could put it in the backyard. You admitted you had room for it. Having a garden isn't a disability, and losing a garden isn't losing a disability. So no, that doesn't count, right? So one of the things I would recommend to all of you is that you have a provision in your zoning regulation that allows your zoning officer, without ZBA involvement, to make reasonable modifications to the regulations that are necessary to comply with ADA. I know City of New Haven has this, and a lot of town of Marlborough, which I represent, has that. it just saves a lot of unpleasantness. If you wind up with the Justice Department, they'll look to see if discrimination was a motivating factor. Here's where that comes into play. If let's say it's ZBA variance for a halfway house, a home for disability. If people start saying at the hearing, we don't want these sickos here, or things like that, right? If you allow that kind of talk to go on, there's going to be the suggestion that you were influenced by that your decision was motivated by those comments. Same is true with 830G, I'll tell you. Some developers will deliberately bring black people to an 830G application in the hope that somebody, some idiot, will stand up and say, we don't want those black people in our town, right? Now they've got you on FHA, not ADA, but they got you on FHA, right? So, Chairman, you cannot let people talk like that. You've got to shut that down immediately. Whenever you hear anything of that kind of thing that is out of order, we will not consider that. I instruct the board, the commission, do not consider what Mr. Jones just said. That is not an acceptable comment here, right? Because it will bite you. It doesn't have to be purposeful or malicious. The mere fact that you were influenced is enough. And the Justice Department will look at the background. They'll look at the letters you received, the comments that you heard, and how you reacted to them. There's a great case, Thomas versus West Haven, where I won't quote from the Supreme Court case because it's laced with profanity, but it's in the case, where two members of the commission just cuss out this applicant, and they brought a civil rights action over that. And the defense in West Haven was, we can't help it if there's two bad apples in the barrel. And the response from the court was, well, you better, because you deprived these people of a fair hearing. And so you better control it. And that's true for all of you. So reasonable accommodation, we talked about, here's your handicap ramp. There is this technical assistance manual for ADA. I would recommend it to certainly your staff people, and if some of you are really anxious, you can read it as well. The other thing I will say to you is that the Justice Department office in New Haven is absolutely fantastic about advising you on ADA issues. I have reached out to them many times. They really go out of their way. They don't want to sue you, all right? They want to help you, and they will help you. I'll mention that in the town of Scotland, we had a home for mentally disabled men that was very, very controversial. And in fact, if any of you want a good read, there's a book called Scotland, and it's not the one in the British Isles. It's here in Connecticut, Scotland, Connecticut, by Gary Greenberg. Gary was the chairman of the Planning and Zoning Commission during that period, and he wrote about the incredible stress of that issue. But the U.S. Attorney for New Haven came out to Scotland and addressed the neighbors and told them this is the law. It's not the fault of your zoning commission people. It's not the fault of your town attorney. This is the law. They're following the law. So they're really great to deal with. And if you have questions, I would certainly recommend that you reach out to them. I'm not getting into the case law. We already talked about that. Questions on fear or? And I'll stick around so we can have our next speaker, and I can certainly be here for anything that you've got. Thanks. Oh, let's see. Do you want 8? No, we're not going to do 2129. I've already touched on 2129, so I think we're good with that.
Okay, thank you. That was just fantastic. I always appreciate your trainings. And next, our next speaker is Sean Gio, a good friend and colleague who is a policy director in Partnership for Strong Communities. Sean leads statewide advocacy efforts on affordable housing and plays a key leadership role in shaping housing policies across Connecticut. And he's going to be providing a debrief on the new legislation that is still in the process of shaking out and what this means for towns in terms of our housing growth. So with that, Sean.
A quick question. Are these slide decks going to be made available to us?
Sure, yeah, I could send them out. And I have everybody's emails. Actually, I'll send them out, and, you know, for those that are members, they're coming out through the squad list. I'll get that out to you and to send out.
Thanks, Kathy. As Kathy said, I'm Sean Gale, Policy Director, Partnership with Strong Communities. We've been around, well, almost 30 years now, since 1998. We formed as a partnership to work to end homelessness in Connecticut, and fairly quickly after formation realized that adequate supply of affordable housing is essential to that. So I've been with the partnership about 9 years now. My background, I was also a planner. I maybe unwisely did not go to law school, but I married a lawyer, so I don't know, that might count something. But our mission, again, is to promote equitable change in Connecticut housing policy. We do that in a number of ways. As Kathy mentioned, we coordinate advocacy, we conduct a lot of our own research, compile other existing research, and we convene a lot of folks to try to come up with policy solutions around housing. And our vision is pretty straightforward. If everyone in Connecticut can find a safe, stable home that's affordable to them and a community of their choice. So we heard about a little bit from Mark about HB 8002, which is an act concerning housing growth. And just in case you haven't been following every little bit of the news the way housing nerds do, and others has to get paid to think about housing. The legislature passed Bill HB 5002 back during its regular session in May, and Governor Lamont eventually vetoed that in late June and said that he wanted to work on negotiating a new bill. So that occurred, and really, as far as we can tell, the negotiations were between the governor's office, the legislative leadership, and they brought in municipal membership organizations, Connecticut Conference of Municipalities, and COST, which represents small towns, and executive directors from some of the council governments to work on this negotiated bill, which became HB 8002, which was passed in a special session along with a few other bills back a few weeks now. So the bill is enormous. I think it's 107 pages long. And I've spent a lot of time with it. So, and in the time we have, I cannot cover all of that. The provisions in that bill, I will say a lot of it, as Kathy, I think, said in her opening remarks, there's details that will remain for executive branch agencies and others to figure out how to implement elements of the law. So tonight I'm really going to focus on some of the planning elements. Mark mentioned 8-30J is no longer the law that required really affordable housing plans without really any description of what that meant. And that's now been replaced with elements of this bill based on a regional housing planning system. So first, I won't belabor this. Mark covered the kind of the state of housing in the state. One thing I will note is the median age of first-time home buyers is now 40, which is incredible, the highest it's ever been. And I'm reminded of my grandfather, VA loan recipient, proud Navy veteran, first-time home buyer. He was maybe 25, and so were my parents. They bought their home when my mom was pregnant with me at 23. Those days, things have changed, and so I won't belabor these points. One thing to Mark's point, there's just a little bit of data around his point about not being able to find apartments in the suburbs. We recently did a paper that one of my colleagues around this concept of rental deserts, the concept of places that have very few rental home options, whether that's apartment, building rentals or single-family rentals, which there's a growing number of. And 41% of, and we use the census tracts to get very technical for a second. The state is broken up into many smaller areas that are more like neighborhood size. And 41% of those across the state have fewer than 20% of their housing stock is rental. You talk about the housing wage, I'm going to go right past that. So I mentioned act concerning housing growth. State's primary goal is to make it easier to build more housing in Connecticut. That was my paraphrase. It'd be a lot longer if you were in the bill. And these are a few of the sort of highlight elements that you've heard. There's some 40-some-odd sections, as I mentioned, it's quite long, but the first one I'm going to mostly talk about is requires this housing growth plan system. There's been some changes to minimum off-street parking requirements and if there's questions at the end, we can maybe cover some of this in more detail. It expands fair rent commissions. Previously, fair rent commissions, towns of 25,000 people or more were required to establish fair rent commissions. That threshold has now been lowered to 15,000, and it creates several new incentive funds to try to encourage towns to permit more homes. Okay, so here we go. We're going to get into the details of this regional housing plan framework, I guess we can call it. Kathy, can you grab a chair for me? Sorry. I hurt my back, I'm going to have to sit down for part of this. OPM, so the first step is the state has to figure out what its housing growth plans targets are for the next 10 years. The Office of Policy and Management, which is really the budget office in the state does not have a state planning office, which is really apparent for anyone that's ever been a planner or worked on planning commissions as yourselves. I also served on planning boards in Massachusetts. So OPM is tasked with doing this, coming up with targets for the state and then breaking those targets up into for each council of government, region, if you will, and providing those numbers to the COGS. The COGS then will assess what they see the regional needs are and assign recommended municipal goals, so for each community. Just a reminder, COGS are membership organizations. Lots of times I think incorrectly they're called regional planning agencies. They're not. There's an argument that you can make that they do that for transportation funding from the federal government, but what they are membership organizations made up of the chief elected official of each town in their community. So when the COGS do assign these recommended municipal housing goals, it will be through your own chief elected officials in your neighboring towns, chief elected officials agreement. So SQUAC, I don't know if anyone's here from SQUAC tonight. There's no one I recognize, but which is a great place. SQUAC will notify Woodbridge of its affordable housing goal that they've determined, and the town can decide what it wants to do. Within 30 days, it can say, okay, that's our goal, got it. And we will work with you on the regional plan. Or it could say, no thanks, we want to develop our own plan, come up with our own goals. Okay, now I'm going to have to sit. I apologize for that. So there's lots of deadlines on here, and for the planning deadlines in the bill, they're out ways. So you can see that the regional housing growth plans, what will happen is the COG will get its goal, it then has to create a regional plan. There's some penalties if it chooses not to. I can get into that later. So for STRAT, their deadline to have a regional housing plan is still quite a ways away. It's June 1st, 2029. And that date will transfer over to any of the communities described that seek to do their own municipal plan rather than follow the regional plan. That aforementioned mother is calling me on my watch as you speak. I'll have to call her back. Plans updated. They have to be updated every 5 years. There's a municipal annual progress report that's required to be sent to OPM. And when you submit your plan, whether it's the COGS plan or your own local community plan, OPM has to act on that in 120 days. It's accept or reject it. But if they don't act on it, then the plan is submitted to this new, the legislation forms this new Council for Housing Development, which is largely made up of executive agency heads with a few, I'm trying to remember now, I'm sorry, I don't have it memorized, but it may also have some legislators on it directly, and then a few other spots for legislative appointments. Okay, that's a lot of detail. Any questions at this point? No, okay. So, now we're back up to the top level, OPM. Go ahead, Larry.
So the state, their housing, fair share that was killed, assigned each town some target. They have methodology to come up with those numbers. What methodology are the COGS using or the municipality?
Right, that's a great question. So some of you may remember the fair share proposal that was put forward a few times in the past that would end up with the state setting specific goals for every community. That won't happen now. It'll be at the COG level or the local communities doing it themselves. And there are some. It's not as prescribed, the methodology for coming up with those numbers, but there are some details in that, what methodologies that they should be using, which I think we'll get into. Well, this one actually, this slide here is how OPM, this is what the legislation says OPM should do at a minimum in determining the state housing need over the next 10 years and then subsequently regional needs based on COGS as the regions. So I won't read all of them, but you can see they're supposed to be reflective of, I think, of housing supply, existing housing supply, and existing really housing burdens that, like what Mark was mentioning earlier, folks that really are unable to, a large number of people are unable to afford any home. Next slide, thanks. Okay, a few things about, now we're at the regional level. OPM says, here's your goal. What's X number of units that you need to sort of permit, show that you can create, right? It's not that the town is creating them, it's planning. The COGS can't make any town's affordable housing go exceed 20% of the town's occupied housing units. Again, the COGS are going to be basing their plan around your chief elected official's opinion as well as his colleagues. So, but that is sort of a circuit breaker there that no town would be forced to have a goal that was excessive beyond 20%. Have to consider the town's duty to further fair housing. If there's any questions about that, we can ask Attorney Brantz. But that is pre-existed in Connecticut law, just reiterated. As Mark mentioned, there's a lot in 8-2, the Zoning and Enabling Act, that is been in law a very long time and just largely ignored at the town level, frankly. And there is some duplicative language in here. This isn't the only place you'll see that in the law, the new law. And so, Larry, this is really getting at your answer. but it's not specific, right? The law does mention a few sources, and like, I believe it mentions what's called the CHAZ data set, which is a census, federal census data around housing affordability. But as many of the planners know, there's sort of very standard ways of looking at this, and if you're in real estate, you know that too, right? These disciplines overlap when we're trying to figure out housing demand, right? Because the fact of the matter is, it is basically as simple as our housing, and affordability is largely a supply problem. You just haven't built any homes in decades, enough homes. So next. I mentioned Housing Development Council, that in one of their roles will be to review the plans and the progress reports, I think, if OPM is unable to do that in the allotted timeline. They will also review whether they're tasked with reviewing whether the state's discretionary grant programs are conform to the state plan of conservation and development goals. One would think they would, but I've since learned that would be naive. And I love this portion of the bill that they're addressing the fact that our public dollars should go to support our state goals. And it's a state goal that we plan for the housing need of the state, right? It's explicitly in at least 2 places in the law we heard tonight. So I think it's wonderful that there's this recognition in this bill that we should make sure that all of our discretionary grant programs at the state level, of which there are an enormous number, fit in with what our action plan says. Because a lot of these programs, they've existed a long time, or they didn't consider those things explicitly while they were designing their programs. So they're going to do that. They're going to create guidelines for transit-oriented districts. I'm not going to get into it right now. I can answer questions on it. There is a section of the law that implements a version of what previous sessions was called Work, Live, Ride. It's incentivizing more dense development around transit station areas. And then the one role I mentioned earlier, acting on municipal regional housing growth plans that OPM has not. And then reviewing housing growth grant applications. So this part is interesting. Hopefully the next slide is the right one. Oh, there's some, can you, well, we'll start here. I may skip a slide later. The grant program, what that's about is this legislation creates a new grant program. I believe it's called the Housing Growth Grant Program. It does not specify an amount of money in this program, but what it does say is that communities are eligible to apply for these grants if they do one of a few things. One of the things is develop and have adopted either the regional plan or the local plan, depending on what the town decides. That would give you access to these grants. Have a transit-oriented community, Work, Live, Ride, I mentioned, or sign a memorandum of agreement with something called the Connecticut Municipal Development Authority, which is a fairly new agency created a few years back that really is supposed to aid towns if they choose to enter an agreement with them in developing housing growth zones. There's part of the thing that makes this very difficult is not to belittle our legislature, but I think as Mark mentioned the incentive housing zone law, which my organization was the prime advocate for back then. And it's an example of this. The legislature, it's very attractive to create new things. It's less attractive to figure out if the things you have actually work. So that's where a lot of the complexity comes in with how this law is going to actually function and why there's just a lot that still has to be worked out, frankly. So I won't get into all these, but I think one that I've heard I've already heard concerns over is this inventory of developable land. There's a definition in the statute of what that means. And that's actually done at the regional level. It's a COG's responsibility to come up with that. Again, if you choose to do a local plan, then it becomes the town's responsibility to do that. And so there are conditions of what we mean by developable. I thought I had a slide, maybe I do later on, so I'll wait on that. And the other one that I've heard concerns about is this identification of specific areas that could be developed via a summary review process. Again, just to make life confusing, summary review is sort of like what people like to call as of right, which I like to call permitted use. In Massachusetts, I think that's what we would have called it. I don't know about here. But they create this whole other thing called summary reviews. It was actually created a couple of years ago for a different purpose. Now they're reusing it, changed it a little, and it basically means a permitted use, let's say. Something that's administrative in its approvals. So the regional plan has to identify areas based on all those other factors that it saw that it thinks the town might want to consider as a good place to do this. And all this is advisory. Okay, next slide. Some of this is advisory, but it's still foundationally important, which, for example, the plan has to explain how it complies with the Zoning Enabling Act. You would think that would be the most basic of factors in the plan. Towns gain their authority, every last bit of it, from the state. The state Zoning Enabling Act is how towns gain their authority to regulate land use. It only goes to make common sense that any plan a town forms must comply with the Zoning Enabling Act, right? But we can't assume that. And now that has to be explained. How? Identification of infrastructure needs, and any planner in the room knows why implementation has to be spelled out. So you mentioned having to lay out housing growth policies. Here's my paraphrased definition of what the law says that means, but there is a much longer definition in the law that I can point you to. If you're interested, I can find it in my notes. Okay, I knew there was a slide on developable land. I don't expect you to grasp all this quickly, but basically it excludes land that's already committed to a public use or purpose, parks, recreation, dedicated open space, wetlands and water courses, of course. Again, a lot of this is duplicative. We don't need this law to tell us that, but here it is. And areas unsuitable for development due to topographic features. Okay, if you're on the ZBA, you know what some of that means. I mentioned incentives. There's the housing growth grant program I mentioned earlier. So, and those grants, dollars are to be used to support new development, the development that the plans are identifying areas for, whether it's pedestrian improvements that the state could fund, water, sewer, lots of other kinds of infrastructure improvements. And then for towns that meet those same qualifying criteria, they also are eligible to receive a 5 percentage point increase in their state school construction reimbursement grant. There's the law has other incentive programs and funding grant programs, et cetera. These are the two that are associated with the planning program. And these are the consequences of which is, if you don't submit a plan and get it approved, then you're not eligible for an 830G moratorium. Some towns, they don't see 830G applications. This doesn't mean much to them. But that is the consequence. And if your COG doesn't submit its regional plan, then they lose access to the region services grant that they get from the state, which is, I don't know about SCROG, but it's usually a few $100,000 each, I would guess, somewhere around there, that your cog wouldn't have access to. Those are the consequences as much as they are. So I have a more complete summary of the bill, and it references sections of the law if you really want to get into the language like I mentioned. And you can find that here. I have a couple of print versions of it too. And if there are questions about other elements of the law now, hopefully I might be able to give you some of that information based off of that summary. One thing I'll leave you with is I mentioned we do our research and publications. We have a publication coming out next month basically on the state of housing in Connecticut. It's a broad look. Some of the statistics that Mark and I talked about what's happening with housing in the state in terms of production, affordability, and otherwise. And so if you're interested in seeing that, it's due to come out on the 16th. So that's it. Happy to answer any questions. Yeah, go ahead.
Hold on one second.
So, I mean, I have a question weaved into observation, which is a kind of a different perspective of this. So, I've been following this for several years, and I've observed that there's some difficulty getting buy-in from some folks in the suburbs. Some folks get buy-in, but again, there's a challenge of getting the buy-in right. So it seems like this is a lot of this is based on discrimination, right? So I'm wondering if you guys or you and your colleagues have, I'm going to take my glasses off here because I can't read. If you've considered looking at this from a socioeconomic perspective, because from that perspective, if you look at the last 4 to 5 decades, income inequality has reached a critical level, and I mean, my perspective is we're essentially living in a second Gilded Age. So, if you take my observation is if you look at these regs, it's kind of like treating the symptom and not the disease.
Yeah, so I completely agree with that. I will say this. Mark was talking about fair housing as one of the underlying things, and there's organizations that is their primary goal, desegregation or integration, and there's the history is what it is, and it's led us to where we are now. And race and socioeconomic status are correlated, obviously, and we'll say, to be generous, in our state, right? So, having said all that, my organization is not a fair housing organization. We're, as I mentioned, our mission is really to make sure that we have enough homes that people can afford, and they're in the places where people need them, and they're the type of homes people need at different stages of their lives, right? So, I wasn't involved in, I don't think anyone in this room had any involvement in negotiating that bill. So, I'm not here to defend it, but I do think it was an honest attempt including with local, like I mentioned, Connecticut Conference Municipality and representatives from the Council of Governments to try to look at more broadly the need for housing, right? Versus what Fair Share was very explicitly about remedying our racial segregation in our state, right? So I think you'll see that in a little bit if Larry's question about the methodology for determining the housing need. I think you'll see some differences between what this law dictates or as much as it does about how to develop that versus what Fair Share did. So, Mark.
Just a couple thoughts on that same thing. That's why I mentioned that the slide about how many hours you have to work a week at minimum wage in order to afford housing in Connecticut at 30% of income. That just increasing the minimum wage took that from 79 hours to 70 hours. And that's exactly to your point. I mean, first of all, a lot of people work for less than minimum wage. But even minimum wage, I mean, that's where income and housing are correlating. And you are so correct. I mean, the numbers are clear. We're moving into a Great Gatsby kind of society of extreme wealth and a very large number of poor to very poor and a shrinking middle class. One of the things that I attended a workshop some years ago on one of those the plans that they worked on, there were the 6 per acre and so on, and the planner had the attendants he had a board, and it had, you know, you're from 0 to 10 to different age groups, and it said for each person attending, put a pin, you know, where you lived at these stages of your life, single family, multi-family, and so on. And of course, all the pins go up, and what you see is that all those, this was a rural town where everybody's living in a single family home. And what you see is that at some point during their life, nearly all of them lived in a multi-family home. You know, out of college, first job, whatever, right? That's how you start. I started out renting an apartment a couple times until I could buy a house. But there's no rental. Where how do you get into that? How do you work your way into that upward mobile cycle? And that's why I also mentioned about how, like, the town, the people who check out your books and plow your roads can't afford to live here. This has real economic impacts. One of the backers of these housing initiatives are the big employers, Pratt & Whitney and you know, all the electric boat and people like that, because they can't hire worker bees because they can't live here. And so it's having an effect on our ability to grow economically. You can't have all chiefs. Somebody's got to be an Indian, and they got to live somewhere.
Yeah, just, I don't have this information with me, so I won't be precise, but to Mark's point, a couple generations ago, the income and the cost of a housing was at a certain ratio, and you know, maybe 3 times your income for the price of the house. It's often lower than that historically. And that sort of conveniently translates to Mark's 30%. We're very close, right, to about what's affordable, 30% of your income. Well, now in Connecticut, wages have not kept pace with housing costs. There's lots of reasons for that. I mean, lots and lots of reasons. If we just talk about the housing side, there's availability of land starts to shrink, right? It's not like it was when my parents bought their house and there were large tracts of land still in the cities. I grew up in Woodbridge. So land costs are really high. In some places they're skyrocketing. And so that's one of the problems. Construction costs are way up for lots of different reasons, right? And so there's been that horrible split of housing costs and wages. They're not together anymore. So what do we do about that? One of the things we can do is try to address the factors that we have some control over in the state. Like I mentioned, land, right? So if you find a place where multifamily housing can work, you're using less land per unit, right? So that land cost is going to be divided up. Or it doesn't have to be smaller lot, single family homes, or et cetera, right? And Mark mentioned manufactured housing. All those things can get at some of those underlying housing costs. But that's not the only answer, but those are the kind of things the state and the local communities can do to try to drive those two curves back a little bit closer together. Now, there's all kinds of income and sort of wage related factors, you know, and I work in housing, so I have my personal opinions about all that. But like Mark mentioned, there was an observable change when the minimum wage went up, right? In terms of the cost burden on typical people. So it's a long way of saying I 100% agree with you, and I think that's the real problem. I think there's no question that it impacts people differently, more severely, that sort of disparate impact that Mark is talking, and I don't think it's fair to ignore that.
Yeah, I think you need to integrate that into your road shows, because if it's just coming across as a discriminatory issue, then you're losing a lot of people.
I just wondered what we can learn from the outliers. If there's a few municipalities that don't have zoning commissions who makes the development decisions in those spots, and also are there states where the power to make decisions is not given to zoning commissions, and that those decisions are made a different way? I'm curious about those.
The first question, I think you mentioned Eastford, right? And I think I heard, I don't know this firsthand, Bethlehem may not have zoning, but everyone else does. And your second question.
Who makes the decisions if they don't?
In terms of land use? Yeah, that beats me, I don't know.
Since I'm council for Eastford, I can answer that one. They have subdivision. They have some planning power, so they can review subdivisions. But without zoning, you can put a warehouse or an apartment building or a factory any place you want in the town of Eastford, anywhere at all. There is no one making those decisions because they've decided they don't want that power. By the way, Pomfret was one of the other towns that had no zoning until maybe just 10 years ago. They just recently adopted it. So yeah, then no one makes those decisions. But outside New England, most of these things are county. I mean, we have the town form, but almost everywhere else, the budget decisions, police, fire, schools, is all on a county basis. So they have the ability to look to paint on a much larger canvas, shall we say.
And does that make it a little bit more equitable at the county level if there is?
I grew up in the county, and yes. One of the things that was an adjustment for me when I came to New England was that there was a bond issue. My first assignment as an intern was in a place called Danvers, Massachusetts, north of Boston, and they had a school that had been condemned by the state fire marshal as a fire trap, but they were still using it because they kept trying to float bond issues to build a new school, and they kept getting voted down. And coming from Maryland, I was like aghast at that. When our county decided they needed a new high school, they built it. And if you wanted to vote against them in the next election, go ahead. But we didn't put the referendum whether to build a new school. You need a new school, you build a new school. And you would adjust the taxes accordingly. And again, if you don't like it, vote somebody else. I have just this idea of going to bond issue on every school and park. And I was like, my God. And I know it's very democratic, but it's also very inefficient.
Well, I'd argue it's not very democratic because of your presentation earlier, right? Who can live where is largely determined by income, right? Often. But to finish up, I just reiterate what Mark was saying. For those of us that have only lived in New England, it's hard to realize that it's not like that in the rest of the country. I've lived in 3 New England states. New Hampshire is not quite, I mean, they have town meetings, which is like, you know, in my mind, it's hard. I worked for a town there and to try to get things passed, it's very difficult, but they have some county functions still in New Hampshire, but largely this is not the way the rest of the country is managed, and I'm sure there's problems, many problems with the other places, but I don't know what they are. But the problem that I see is, as a former planner, is that our towns are so small geographically that they're not based on, like, say, labor markets, for example. So we can live one place, I live in Cheshire, and not pay any taxes, really, to support a lot of things that are in other communities that we use, whether they're hospitals or what have you, right? So we can, you know, be free riders to a certain degree, right? And that's allowed because our geographically are so tiny. I went to school in London. London is surrounded by Waterford, so, and it's narrow. It's just along the Thames River, so you can move, like, literally a few houses, and then you no longer have to pay property tax in London, but if you like doing things in New London, it's just as convenient. So, I mean, that's like a kind of underlying problem that probably is never going to change, and we have to figure out our solutions based around that, right? And the only reason I say that is I used to work for a state senator 25 years ago, and he told me, people are going to always want to talk about regionalism, and don't waste your career on it, because we haven't gotten anywhere, right? But there is some inroads with, like, shared services. I think some towns recognize combining together. You guys, I believe you have a regional school, high school, right? So you figured that part out, right? So, pardon? Doesn't include, absolutely, doesn't include you.
Yes, hi, I'm a resident of Woodbridge. I just want to talk a little bit about myself and my husband. I'm a licensed real estate broker. I've been in real estate since 1980s. I worked in Chapel, back when Chapel was out, when Chapel was in. I'm also a licensed mortgage loan officer and a licensed insurance broker. My husband joined me in this industry about 30 years ago. He's a licensed mortgage loan officer. He alone has put about 800 people into home ownership. My first client was a woman named Clara Henry. She was coming out of Elm Street development. She had about 8 children and about 14 grandchildren, and I found a house for her on Howard Avenue. I got a program from People's Bank, and it was the Chaffa deal, and this was back very early on. I was doing everything to get people into houses. I was doing seller concessions, finding programs, 3% down. People were asking me at my real estate broker, how are we getting people in? They were still doing 20% down deals. I was just trying to get them in. I was doing creative financing. It took me 6 months to get Clara Henry into her house. Clara didn't have enough income. Her credit was bad. We told her to work overtime. We told her to cut her credit cards. And after about 6 months, I finally got her into a house. I say this because we changed Clara Henry. We didn't change Howard Avenue. Unfortunately, I have to tell you, I'm not happy with this. I'm extremely distressed about these bills. It seems as if you mentioned African Americans, you mentioned segregation, these are truths. You mentioned generational wealth, and then you went right back to Section 8. Section 8 will not give you generational wealth. You're taking a whole population of people and making them second-class citizens. That's how I see this. So there is a way of getting people into home ownership. There's a lot of conflating going on here with using this discrimination and then going back to Section 8. We're trying to get people off of Section 8, not putting them back on. And what is distressing me is that you're incentivizing people to get back on Section 8 when what we're trying to do is get them off. So I'm older now, I would have said this 20 years ago, but I'm trying to tell my truth now. We see people people on a day-by-day basis. We talk to them every day. Today I was in the car with my husband, a woman called up. She was 56. She was an African American, trying to buy her first house. The reason why she hadn't bought her house was her rent was so low. But in actuality, her income was over $100,000. So Section 8 has problems with it, and you haven't discussed that. It is income restricted. It encourages single-parent families. There's a host of other things. So this is my feeling about it. I just wanted to make it known. I'd love to help the situation, but I don't feel that this is the direction of getting people back on Section 8 and motivating it. If you had a mitigating program, if you had career development, if you had things along the way to help people, if there was a limitation on the time frame, fine. But we see people on Section 8 for 20 years. That is not the way and the path that we're looking to go. So I just wanted to say that. Thank you.
Thanks for your comments. One thing I'll say is, again, I'm interpreting the bill, just summarizing it. I'm not responsible for it. I don't know that there's anything in this bill about vouchers other than a very small piece about reopening a state program, open choice voucher program, refunding that. But I do want to say this. I was talking about housing costs and income not keeping pace with housing costs. There's a concept of minimum rent. So I build a house, or apartment building, it costs me a certain amount of money, to run it, operating costs, property taxes. I will not build that apartment if the rent is lower than that, right? So if I'm a poor person, how am I going to find those apartments that my only affordable rent is below the minimum rent? Well, luckily, thank God, Connecticut has a housing voucher program called RAP. And the majority of folks that receive those vouchers, the vast majority, I believe it's 70-something%, are disabled and or elderly. They do not have the adequate income and never will have adequate income to afford the minimum rent. So I understand you have anecdotal stories. I do as well, along with facts. Voucher programs are an essential tool to getting to a point where everyone can afford their home. Not everyone will get to a point where they will be able to afford to buy a home, nor rent one on the open market without the voucher programs.
I'll add is the only time I mentioned Section 8 was that it counts toward the 10%. I don't think I think that's the only time I said anything about it. So I mean, it's a tool. It's a tool in the toolbox. It's not the only one, and it can't be the only one.
Any other questions? Larry.
When I try to explain affordable housing and 80% of AMI and 60% of it, it's easy to explain it in terms of rent. Right? I struggle, how do I explain it in terms of ownership? If I buy a house at 80% of AMI, I don't understand how that works. Is it the mortgage can only be 30% of my income?
It's total housing cost. So like if in an affordability, most affordability plans will include both a rental calculation and a purchase calculation. And that's because in the case of, let's say, a multi-family development, a lot of times when you first build it, they're not sure if they're going to do conduit or rental. Single families are pretty much purchase. But so it's the 30% has to be mortgage for purchase. Your mortgage payments, your utilities, your taxes, all housing costs. All right, that has to be factored in. And basically, if you see what one of these affordability plans look like, they will list all these different costs, and then 30% of By the way, at 60% of median is about $48,000 a year, $50,000 a year, and the 80% is about $65,000, $67,000 a year, which is why I say these are people with jobs. These are people working people. And you say, okay, so if that's the monthly housing budget, right? 30%. Then what house can you? What's the maximum this house can sell for, right? And then it's deemed restricted thereafter. And same with the rental, the rents. You work backward. You start with the 30% housing cost, and you calculate then what house will that buy or what apartment will that rent.
And it's based on a 30%, a 30-year mortgage.
Yes, that's what I've usually seen. I've usually seen a 30% mortgage, and usually 10% down.
Yeah, I don't know that.
Yeah, I think.
Would you say that most, vast, what percentage of these
Most of the 830Gs are rent, but I'm trying to think. Well, Colchester had one that's purchase. That's a purchase home, single family home purchase, and clients of mine did one in East Hampton. Their first one in East Hampton was single family purchase, and I'm trying to think of other. They can be the purchase also, and then you have this sort of hybrid, which is the mobile home park. Mobile home park where you own your house, but then you lease the land beneath it, and that includes, of course, the snow plow and usually water and sewer and things like that.
And suppose after 10 years I want to sell my house.
You can.
And how much can I sell it for?
You can sell it for the price that is affordable. If, let's say you bought a 60% of median house, okay? You can sell it, let's say, to the owner for 10 years, right? After 10 years, you can sell it to another family that is also at 60% of median income and what they can, whatever that is at the time, and what they can afford at 30% of their income. So you bought it for less than market, you sell it for less than market for 40 years. And believe me, there is bitter complaint when that happens.
I think Mark was talking about compliance with rents for 830G. I think it's even more complicated for some of the for sale properties because the town sort of institutional memory may pass with some of these developments to how this subdivision's been around for 25, 30 years. Who's left that even remembers, and how does that get triggered in a sale? I'm not, you're a lawyer.
Since it's public information, I can tell you that Colchester single family, what the developer actually did was he sold the designated affordable units at market price. And he got away with it for the first several until they finally did catch him. And then they shut down the whole development. It was in litigation for years. He sued me personally as attorney for the town of Colchester. He sued the town planner. He sued the zoning enforcement officer. He sued everybody, all right? But they finally did. They didn't end up, by the way, with what he promised them, what he was supposed to build. But they did get affordable housing units out of it. But that was exactly what happened. They had a vacancy in the town planner's position. They had a vacancy in the CEO. The new people coming in didn't know. One of the things that we face in every town is this tunnel vision. The building inspector looks at the building code. He is blind to everything else. The wetlands officer sees the ENS and is blind to everything else. The health district looks at the septic system and is blind to everything else. And that's what happened here. The health district said, yep, septic is okay, and the building inspector said, yep, meets the building code, and nobody asked, are they being sold to the people that are required to be sold to? And they did catch it, but it didn't happen right away.
I think the ownership model with using 830G is a great one, so trying to figure out how to make it work better, I think, is a worthy challenge. One thing I wanted to ask you, I heard of a subdivision, I think it's in Stonington or maybe North Stonington, where it's an 830G, and maybe as part of the affordability plan, they explicitly have worked with the Habitat for Humanity, and I think to try to skip through a lot of these potential problems, working with a nonprofit like Habitat, seeks out the buyers. It's a known sort of process. I don't know if that's done anywhere else, but I think it's an interesting model for trying to use 830G for home ownership. And one wrinkle about it is I know Habitat had to basically build to a higher standard than what they normally do. In order, because the town required, they wanted the properties to be very similar enough, right? I don't know what standard they all agreed to.
One thing I didn't mention about it there, G, I mentioned that the units have to be evenly distributed throughout the project, but also the law requires that they be of comparable workmanship. So for example, comparable units. So for example, a developer can't say, I'm making all the one-bedroom units affordable and the two-bedroom units market. You can't do that. It has to be the same rough square footage, same proportionate number of bedrooms. And by the way, in a rental project, they are always exactly the same. And the reason for that is no developer is going to waste money buying 30% of the sinks for, countertops for less. They're going to order sinks and countertops and carpeting for the whole place. All right, it's not worth it to them to pick, to cheapen the finishes in one unit. They just don't bother. And this was one of the things in Colchester too, was that he tried to build smaller houses for the affordable houses, and that was also part of the dispute. It is much easier to do in rental for sure, but I have done several single family. One I did in North Stonington, but I don't know that they teamed up with Habitat for Humanity, so it may be a different project. But the one in East Hampton was incredibly successful. The one regret, I'll just, because the comparability, my clients were super. The one thing was all the houses had gas fireplaces. The market units had a chimney, which was fake, because as you know, gas fireplaces, the vent is sufficient, okay? The affordable units had just the vent through the wall. And they told me afterwards they regretted that, because people caught on that you could identify. Other than that, all the houses are equal square footage, equal lots. I mean, they're all the same. It was the one thing. And they said, for the small cost of that fake chimney, we should have made them all the same, because it allowed you to identify which were the affordable ones.
Hello, I'd like to say thank you very much for the information session. It was really good. I learned a lot of stuff. Thanks for organizing. I think the Housing Commission organized this, so thank you guys. So I definitely support everything you guys said, but I do have some questions that I'd love to hear your opinion on. So something that I've noticed, and could be totally wrong, this is my impression, is that we have to go for a lot of different housing strategies to try to get the houses that we need. I also happen to be, have a very strong environmental ethic, so I can tell you that like some of those strategies are consistent with conserving the environment and environmental justice. All these things are very important. Some of those strategies are kind of disastrous to the environment. My impression is that housing advocacy groups are not very good at differentiating between those different strategies. And what I notice happening is that if any group says they're against one of those strategies, they sort of get labeled as anti-housing, which is not necessarily the case. And then you just sort of have people in the community fighting with each other. When in fact, I think that if housing advocacy groups could sort of learn to differentiate those and focus on the more environmentally friendly options, I think we could actually build more houses faster and make more units faster, because there would be less resistance in the communities. And so, this is just my observation. I don't know if maybe I'm totally off here, but I'd love to hear your thoughts on this.
Yeah, first I'll say there's a lot of different organizations that are advocating for housing. I mentioned earlier, Mark mentioned Home Communities Alliance, which I know Woodbridge is familiar with. We don't all have the same goals, and we don't have the same approach to solving these problems. I agree with you, some forms of housing are less desirable than others, and I think we have, my opinion, we've had generations of the least desirable form, large lot subdivisions, that have eaten up the state, contributing to traffic, emissions, lack of, the ability to walk anywhere, lots of things, right? And rising the cost, underlying cost of the home, right? 3 acres costs a lot more than a quarter. And so I would say it's hard for our folks to do this, but to differentiate between, not everyone has that same view, all right? And this bill that was passed does have some very modest, optional things that towns can do to, for instance, work on creating a transit-oriented area with more dense housing around, I mentioned around train stations. I know you don't have one. I'm not sure what your bus network is like, if anything, but those would qualify as well. So I think there are a wide variety of policies, and a lot of that is based upon a diversity of goals as well, right? As I mentioned, my organization's goal is that people should be able to have a home they can afford. It's foundational for a prosperous family, but also a prosperous society. We used to get closer to that. We've moved very far away from that. We've never had a state where everyone could afford their home, and we shouldn't pretend we did, but that's our goal.
I think that's where the transit-oriented development piece comes in, because that is the idea of concentrating people close to mass transit is very environmental. You avoid those long supply lines. Sean's absolutely right about the large lot, the property large lot. You can't survive without a car in most suburbs. There's mass transit isn't viable because the densities are just too low. I think the other thing though that's happened is that someone who represents both towns and used to do more developers, including A30G developers, is that the environmental protection piece gets exploited, it gets abused. I was at an A30G hearing for a developer in Waterford, where the neighbors hired an environmental expert, true expert, who said that because this development, she testified this in public, that because the development would be renters, and because renters move a lot, that renters tended to throw their furniture and other belongings down the bank into the wetland. And therefore, there would be adverse impacts on the wetland from having rental people next to the wetland. Give me a break. So that it discredits the entire environmental movement when you have nonsense like that coming up at a public hearing. As I said, A30G is the antithesis of good planning. Good planning would be that you have higher density housing, close to services, close to jobs, close to public transit, okay? But towns were mandated to do that kind of planning and zoning for decades and never did. So it's kind of, these laws should have come out of the books 50 years ago. We probably wouldn't be here. But you're absolutely right. We should be planning. Coastal resiliency is huge. Increase in sea level. These are real, despite those who say it's a hoax. It ain't. Those are things we have to be thinking about, and that's going to mean putting more housing in areas that are environmentally suitable in order to preserve the areas that aren't. But the thing, everybody wants to be in the place where the developer shouldn't be in. No one wants to have it around that. Indy.
Thank you.
Is there any more questions? Okay. Well, I just like to have a round of applause for Attorney Mark Grant and Sean Gill. I think this was a very important discussion and informational session, and as you can hear from the new legislation, the new housing growth bill, we have a lot of work in front of us, and we're going to have to work together and figure this all out, because are going to have housing growth in our towns, in our communities, and in our region. But thanks everybody for coming out tonight.